just get that off my chest, in his address on this bill, talked about how the military perhaps should remove this government. And here is this opposition that's been talking. Honorable Prasad always talks about we don't support military intervention. Not a peep out of him. All of these other people, you did not say anything to him because you're obsequious to that side. The other point is that this opposition continuously talk about military intervention, saying it's bad, yet none of them said anything, whilst they, now Shadow Minister for Economy, talked about military intervention. Mr. Speaker, sir, I'd like to highlight a number of issues, and there's been a lot of obfuscation that has taken place. I'm actually quite agitated about it, frankly, because, and I'll start off with Honorable Prasad. He said, Honorable Prasad said, that I said that the FLS submission was in cahoots with the opposition. I said that only in reference to, if he listened and if he was honest intellectually, I said in relation to the second last paragraph by the FLS where they accuse you, Mr. Speaker, sir, of, and I'll read out, the changes being proposed in both bills are so profound they must certainly be carefully considered. With respect to restrict matters of such great public importance in 1 hour's parliamentary debate, as suggested by the Speaker, would be a serious failure of leadership. That's the bit that I said you were in cahoots with. Please be intellectually honest. Anybody that knows the law, including the Law Society, should know this, that the time given for a debate under 51 is not set by the Honourable Speaker. It's set by the person moving the motion. It is an affront to the office of the Speaker to suggest that. And this is the Law Society on whose submissions you are basing your whole argument on. Mr. Speaker, sir, the reality of the matter is that they chose to firstly get the law wrong, and they chose to formally, through this letter, be in cahoots with their position, political position. That's why I said that. In respect of all other submissions they made regarding the separate division and jury system or assessor system, I made comments on that specifically. Please don't obfuscate matters. Mr. Speaker, sir, I would also like to, and I'll start off with Honorable Prasad. He says, you know, he relies on the Law Society saying that it's not a serious matter, it's not complex. Let me read from what the FICAC statement said in relation to that. It says, FLS states corruption is not so complex, so widespread. This statement by FLS is misconceived and delusional. To allude that corruption is not widespread is a barren opinion which obviously neglects the ground reality of the seriousness of corruption that the country is fighting. Corruption is polycentric and multifaceted. It is the gateway for the occurrence of many other serious crimes, including illegal drug importation, tax and customs breaches, fraud and serious financial crimes, money laundering, human trafficking we talked about, terrorism and terrorist financing. The impact of corruption to the economy and society at large is irreversibly detrimental. Corruption cases can also become complex and often require lengthy and cumbersome processes to bring the culprits before the court of law. A realization of this important factor has made several countries to change the traditional response to fight economic crimes, including fraud and corruption. The introduction of the Serious Fraud Unit and the National Economic Crime Centre is the United Kingdom's response to white-collar crimes and corruption. Likewise, in the United States, I know you're obsessed with first world countries, likewise in the United States, the National Institute on Economic Crime is responsible for providing specialized training and advice to the relevant law enforcement agencies. In Fiji, there have been and are many complex corruption cases before the courts to which the Fiji Law Society seems oblivious to. It goes on. Mr. Speaker, sir, I want to also pick on the point made by Honourable Nawaikula. He turned this whole matter into some personal matter. He thinks that this division is being created because they have been charged relating to whatever offences they've been charged with. Mr. Speaker, sir, let me also remind him that it was not only members from SODELPA that were charged, it was also a member from the Fiji First side that was also charged. If there was any political ostracization, political targeting, vindictiveness, then nobody from this side would have been charged. In fact, he had actually he did the honorable thing by actually resigning. Mr. Speaker, sir, there is absolutely no nexus. No nexus has been shown between the creation of this division and any form of political victimization. Mr. Speaker, sir. Number two, Mr. Speaker, sir, nobody from the other side has stood up and given one iota of logic to draw any inference or direct or indirect inference to say that the rights of any individual will in any way be deprived. Not a single iota of argument has been put forward. Not one. Mr. Speaker, sir, I remember I used to be a member of Transparency International when I was in the private sector. I was also a member in the private sector. We went, when it was the International Year of Corruption, the then SDL government was here. I remember going with two other members from TI to the Prime Minister's office to urge them to ratify UNCAC, United Nations Convention Against Corruption. They refused to do so. When the Bainimarama government was appointed, that was one of the first conventions they ratified. Today, Fiji is part of a peer review group under UNCAC. We volunteered ourselves to be part of the peer review program, so other countries, including first world countries, can come and review our compliance with UNCAC, which includes, are we using it for political purposes? Not a single peer review has said that has happened. Not a single peer review has said that has happened. Absolutely no evidence to suggest that. We only have this kind of comedy of errors being made from the other side. People stand up, make all sorts of ridiculous comments with clapping coming from Honorable Rasoa, who's got the loudest clap, and everybody cheering. This is a mob mentality with no logic. Mr. Speaker, sir, Honorable Prasad did acknowledge this. The reality of the matter, the World Bank report said in 2006 that 1/3 of Fijian economy was in the black. In other words, illegal dealings going on. How does that happen? It means somebody's on the take. At the border, police, biosecurity, wherever it may be. Isn't it better to get that black economy back into mainstream economy? Shouldn't we be serious about that? You want to pull out Afghanistan just as some kind of scapegoat? To say what's happening in Afghanistan, that's why. Honorable Wanganika talked about that, how many cases will they hear? And so she's using frequency of cases as an argument not to have a separate division. How many cases does the tax court hear? How many cases does the court of review hear? You have not gone into those statistics. Sometimes the tax court hardly hears any cases. Yet we have a specialized court. The logic does not follow through. Mr. Speaker, sir, Honorable Prasad said we did not inform that these bills will be coming. We mentioned in the business committee, if you dare to attend, you send always your representatives, we told them, we read out the bills that will be presented. Get it right. Yes, we did not tell the content, but we said these bills will be presented on these acts. Mr. Speaker, sir, the reality of the matter is, Honorable Prasad then went on and said, we should have public consultations. Earlier on this morning, the member sitting behind him complained about the climate change bill having too much public consultations. You said, we know why they're doing public consultations, because they're going to fast-track it within the committee stage. So he's lamenting the fact that we got too much public consultation. Which one is it? Which one is it? Mr. Speaker, sir. Mr. Speaker, sir, the reality of the matter is that in the second bill that we're going to discuss, if you look at the rationale, Honorable Wanganika touched on that particular bill, but we talked about actually sexual offences and the nature of patriarchy in respect of how it infiltrates in the thinking of the assessors. Mr. Speaker, sir, we've had widespread discussions with the Chief Justice, the Honourable Chief Justice, about this very issue of our specialised courts. And, Mr. Speaker, sir, What we are saying and what discussion has been, at the moment, because the volume of the cases and the jurisprudence that is already developed, the judges and the magistrates have a lot of capacity in hearing these cases. And, Mr. Speaker, sir, there has been a lot of judicial training in that respect. The DPP's office has got a specialized office regarding that. So it does not in any way negate or derogate away from giving emphasis to those types of offences. Mr. Speaker, sir, the Honourable Nawai Kula, I think, has got a very warped understanding of jurisprudence. He thinks that jurisprudence can only be developed by the appeal court. Not necessarily. Not necessarily. Even the High Court develops jurisprudence. In fact, most cases do not go beyond the High Court. And jurisprudence set by the High Court actually is followed by the Magistrates Court. He knows that. To simply every step of the way, he argued 3 times, oh, the appeal court is there. Oh, the appeal court is there. No. Jurisprudence are also developed by the lower courts, other than the Court of Appeal and the Supreme Court. Mr. Speaker, sir, there's a couple other issues that I also wanted to highlight. Again, there is this argument that by having a separate division, that there'll be interference with the judiciary. How does that logically work? Does this amendment say that government will have an input into it? Does it alter the way that judges will apply the law? Does it in any way say that the selection of those judges and magistrates that will be sitting in this new division will be selected by somebody else other than the Chief Magistrate or the Chief Justice? Not a single shred of evidence, yet we have lawyers. Honourable Wanganika said that she and the Honourable Nawai Kula are the only practicing lawyers here in private practice. I didn't know Honourable Nawai Kula is again practicing because I thought he was suspended. But the point is, he's probably back in. But the point of the matter is that it does not in any way mean that the judiciary is going to be interfered with. Absolutely not. Not a single shred of evidence. They say it will have an enormous impact on the budget. No. It's a division created. We don't physically go and create a division that requires money. It's in law. Again, without any verification of facts. Mr. Speaker, sir, and there is going to be consistency in decision making. In one of the earlier things that the Bainimarama government also did, Mr. Speaker, sir, was that it set up a commission of inquiry into the magistracy in Fiji. And those of you who've been practicing for quite some time will know the couple of magistrates who actually were on the tape. And when the complaints in one particular town or city got too much, they just simply moved him around. The last town that he was in Nandi. The Commission of Inquiry found out that the going rate for him for careless driving was $1,500. Dangerous driving was $2,500. Rape was $5,000 in those days, rape. He had an agent in the market where he paid the money and the magistrate dealt with him. After the Commission of Inquiry ended, that magistrate lost his job based on the findings of that particular Commission of Inquiry. These are real issues pertaining to the judiciary. Recently, the Honourable Chief Justice found out that there were certain court clerks in Lautoka where evidence, if you've seen, has gone missing. In the exhibits room, has gone missing. Files don't get appeared before particular lawyers, or files disappear. These are real issues that need to be addressed. Not a single member has spoken about that. Nor have they drawn any causal link between this amendment and the practice of the judiciary. So, Mr. Speaker, sir, again, I think the Law Society, of course, can write any letter. It represents about 19.9% of all the lawyers in Fiji. I've got the statistics here. There's about 894 lawyers who have total number of lawyers who are practicing certificates, of which 178 are members of the Fiji Law Society. The other 80% of the lawyers are not members of the Fiji Law Society. So, Mr. Speaker, sir, obviously it is not representative of all the lawyers in Fiji. In fact, it is a representation of a minority of lawyers in Fiji. This is not to say, of course, that minorities cannot make worthwhile comments. Unfortunately, in this particular instance, they did not make a worthwhile comment. So, Mr. Speaker, sir, again, we like to urge all members of Parliament to essentially look at the intent of the law. The intent of the law is to create a specialized division that will deal specifically with these cases, that will develop the jurisprudence. We've seen cases where some magistrates or judges who are averse to white-collar crime knocks off something on what we is called overseas a non-material technicality. Technical, we say Honorable Wanganika should tell us that. Honorable Nawikula should also know that there are material technical glitches and there are non-material technical glitches where things can actually be rectified, or rectified, I should say. And it's only in those cases getting knocked off. People with similar offences, the Lambasa magistrate maybe actually send somebody for 3 years, the Nandi guy decides to do it on a similar offence, commission of the offence, 3 months, or suspended sentence. These things, Mr. Speaker, sir, does not lead to certainty in law. It actually undermines the rule of law if it continues on a long-term basis. What we are seeking, Mr. Speaker, sir, is a specialization and demonstrating our commitment to eradicating systemic corruption in Fiji. Thank you, Mr. Speaker, sir.
I thank the Honourable Attorney General for his right of reply. Honourable members, the Parliament will now vote. The question is, pursuant to the resolution of Parliament on Monday, 8 February 2021, that the High Court Amendment Bill 2021 be debated, voted upon, and be passed. Does any member oppose the motion? Yes. Honourable members, there being opposition, Parliament will now vote by acclamation. Those in favour say aye. Aye. Those against say nay. Nay. The ayes have it. Honourable members, Secretary General.
Bill for an Act to amend the High Court Act 1875, Bill number 1 of 2021, enacted by the Parliament of the Republic of Fiji.